We'll take up this matter after the other portion of the other list is completed.
Daily cost list, item number 1.
May it please your lordship. Well, this is that application for bail involving commercial quantity. An HIV positive patient is before this honorable court. Well, lordship was pleased to call for the records on the last statement. This case, my lordship himself had granted bail to this particular accused person in a case involving non-commercial, intermediate quantity, my lord, on the ground that she's an HIV positive person. At that point of time, my lord, even I was not aware that she was already shown arrested in another case within the same police station, my lord. Even the state did not bring it to the notice of this court. When we went for the acceptance, we realized that we were told that she is arrested in connection with some other case. The application for bail was preferred, and it was rejected on the ground that this accused person was shown arrested in connection to this particular case. Now, I have only two grounds of argument before this honorable court, my lord. One ground is that, my lord, if the argument of the public prosecutor is to be taken that she was shown arrested in this case, then, my lord, the concept of shown arrest is something which is not there in criminal jurisprudence. My lord, a person cannot be shown arrested. Arrest has to be made, the person has to be produced before the magistrate if the person is already in custody in connection with some other case. I have a judgment to show that to the defect also.
That is the normal course, yes.
Yeah, my lord, person has to be produced then.
Has to be produced. The formalities will follow.
My lord, lordship. But my lord, I am not privy to the order sheet. So my lord, I can only take it from what is being stated in the order that the public prosecutor opposes to this bill on the ground that this is a commercial quantity. Rigors of 37 will come into play, and also that this person is shown arrested in connection with this case. So my lord, now just to impress upon this court, my lord, that a person cannot be just shown arrested. A proper arrest has to be made. I have a judgment of the Calcutta High Court, my lord. In fact, at that point of time, this judgment was by our own Chief Justice, my lord, Mr. Sanjeev Banerjee. Just to impress that, my lord, if it is a case that the person was just shown arrested, then, my lord, a case for bail is made out, my lord. But, very short judgment, I'll start from paragraph 3. An independent case was sought to be started against the petitioners, and they were arrested in connection with such independent case under the NDPS Act, but it does not appear that the petitioners were produced before the magistrate within the time prescribed on the Code of Criminal Procedure in 1973. The petitioner referred to a judgment reported at such and such to assert that it is a constitutional mandate that the person has to be produced before a magistrate within 24 hours of his arrest. In such context, the petitioners referred to both Article 22, Article 21 of the Constitution in addition to Section 46 and 57 of the Code. It appears that a prayer was made on behalf of the state before the additional district judge, the Special Court presiding over the NDPS Act on May 17, 2018, the material part of which read as follows. Considering the circumstances, I pray that PC, accused person above name, may kindly be shown as arrested in such and such case. They will be produced before the court of the learned CJM at Barasat today, 17/5/2018. The petition is in the form of a letter under the signature of sub-inspector by the name of such and such, and was apparently placed before the court through the public prosecutor at Barasat. It is now necessary to notice an order of May 17, 2018 passed by the special judge in case number such and such under section such and such of the NDPS Act corresponding to Dattapur Police Station case number 420 dated 16/5/2018. The order recalls that the court was in receipt of the application from the aforesaid investigating officer with a prayer for shown arrest of the accused person. The operative part of such order reads as 19/5/18 for production of the accused person, and further order, IO is directed to appear before this court on that day on 19/5/2018 at 10:30 am with CD for consideration of his prayer for shown arrest of the accused person. Clearly, the accused person had not been produced before the special court on May 17, 2018. Whether or not the judge should have recorded the order or directed the production of the accused on May 19, 2018, it is evident that the fresh case was started on May 16, 2018, and the petitioner were arrested in connection with thereof without the petitioners being produced before any magistrate or the special court within the time mandated by the Constitution or as provided for in the court. In view of the dictum of the judgment of the Supreme Court cited on behalf of the petitioners therein, the immediate consequence is that the petitioners have to be enlarged on bail if not discharged altogether. Now, my lord, here also, my lord, because I am not privy to the order sheet, the only thing I can see here is, my lord, if I can take, my lord, to page 15 of my application.
Yes.
Well, the last two lines of paragraph 2, my lord. Hence, she was shown arrested also in the case White Clariot PS case number such and such. Well, this is the submission made by the public prosecutor opposing my bail application before the trial court, my lord. Well, this is one ground. Well, the other ground, my lord, of course, my lord, here, lordship, she is accused of contraband involving, commercial quantity of contraband. Well, I do understand my limitations. My lord, rigors of 37 will apply. But the only evidence that the prosecution has is that, my lord, the co-accused has taken my name and that I was in constant touch with the co-accused. Now, statement of the co-accused is not something, my lord, which would lead to my conviction at the end of the day. And also, my lord, even CDR is not substantial evidence.
That would be a matter of trial.
Absolutely, my lord, it will be a matter of trial, my lord. But at least my lord, to curtail my liberty, my lord, there has to be some substance in the charge sheet of the prosecution. There is nothing except that the co-accused has taken my name, and apart from that, we were in touch with each other. I am not denying the fact that I know the co-accused person, my lord. And well, as far as
The only consideration that this court may consider is
My lord.
the aspect of the
Illness, my lord.
the shown arrest.
If it is such, my lord, because I am
concept.
only. If I was privy to the order sheet, perhaps, my lord, I would have placed a copy of the order sheet also before this honorable court. But if it
We
is,
can call for the order.
my lord, that can be. And also the fact that, my lord, I suffer from
Because
HIV.
see, in the light of section 167, that has to be.
Absolutely, my lord.
Once a person is, I need not say that. Everyone knows it for a fact that if a person is arrested within such and such time,
Has to be
24 hours, he or she has to be produced for the magistrate. If it is not, then that becomes,
Yes,
the arrest becomes
illegal.
illegal.
But one aspect of the argument here, my lord, she suffers from HIV. And, my lord, it is the son who has to provide the medicines, my lord. They are not providing her medicines at all. She has certain liver ailments also. My lord, every now and then when she needs medicine, my lord, the son has to go all the way to Clear. They are not providing any kind of, my lord, medical assistance to this particular person, my lord. Whenever any medicine is required, it is the son who has to. My lord, it is the jail authorities who should take care of this person, my lord. It is very difficult for this young boy who stays in Shillong to travel every now and then to supply medicines, my lord. So on that aspect, my lord, if my learned friend can, my lord, enlighten the court whether the procedure of arrest was followed or not. Of course, if it was followed, then, my lord, my argument fails. But from the submission of the public prosecutor, my lord, he says that I was shown arrested. If that is the case, then, my lord, I can press for bail, my lord, only on that count.
Yes, yes.
Lordship, prior to that, my lord, with regard to a non-available of medical facilities, Lordship, there was another case, I think in the year 2016 or 17, Lordship, whereby bail was denied to an HIV person because the medical facilities were given, Lordship. But if it's coming from the council that no medical facilities are given, Lordship, we will have to seek instructions on that, Lordship. Because that time also I was in the government IRP on that particular case. Same ground, Lordship, HIV positive, but that was for 302 IPC. So ground was bail was denied, Lordship, because the medical facilities were availed by the accused person in the jail premises, Lordship. So for that, Lordship, first time I'm hearing that, so I'll have to ascertain, Lordship, whether that is actually a fact. Because if 5-6 years ago it was provided, then I'm quite surprised if it's not provided now.
It should be provided.
It should be,
But
Lordship.
my lord, it is my submission, my lord, that I am supplying medicines over there, my lord. I am asked to supply medicines, they are not supplying.
Oh, you are asked to.
I am asked to, my lord. They are not giving her. Because, my lord, a person whose immune system is compromised, and, my lord, the internal organs, my lord, you may have a kidney problem, you may have a liver problem. In this case, this lady has certain liver ailments, my lord. HIV itself is not a disease, but then, my lord, the immune system is compromised, so other...
That's understood, Lordship. But I'm just placing before this honorable court that same ground being HIV denied because the medical facilities were there. So if I may
That's
kindly...
one aspect of the matter.
Lordship.
The other aspect is the concept of shown arrest. Where is it found? And how would it relate to this particular case?
My submission on for shown arrest is only on the submission made by the public prosecutor, my lord. I am not privy to the order sheet. If that is the case, then, my lord, of course, it is illegal. The arrest itself becomes illegal.
Lordship, may it come at the bottom of the boat, my lord. I'll just do what is necessary to get.
No, the boat.
Item number 3.
Obliged.
With this, Your Lordship. Your Lordship, kindly let this matter come at the end of the board as the learned arguing counsel is on his legs.
The boat. Yeah.
Your
Second call from supplementary cost list.
You are in this case.
I'm there, my lord, in this case.
So we'll wait for Mr. Yubin.
Supplementary cost list, item number 2.
My lord, here I am here aggrieved by the order dated 15/6/2022 passed in CR case number 87S of 2012. Now, look, this CR case 87 of 2012 is a proceeding initiated under section 138 of the NI Act. Now, before I take my lord to the impugn order, a little bit about the background of the case. Now, my lord, what had happened is, on default of a certain sum of payment, against supply of ferrosilicon to the respondents, the petitioner lodged an FIR. At Umiam PS, which was registered under various sections of law, including 418 and 420 IPC. Now, what had happened was that in the month of 2008, four consignment of ferrosilicon valued at rupees 46,79,890 was supplied to the respondent, against which the respondents made a payment of only rupees 10 lakhs. Thereafter, repeated demands were made for the outstanding sum of rupees 36,79,880. No payments were made. Now, with seeing that no payments were forthcoming, the petitioner filed an FIR, which was registered as Umiam PS case number 4310 under various sections of law, including 420 IPC. Now, after the FIR was filed, the respondents came forth and a settlement was arrived at. Now, in terms of the settlement, along with the outstanding dues and the interest accrued thereon, the sum which was liable to be paid by the respondents to the petitioner came to about 71,34,439, out of which a sum of rupees 40 lakhs was paid, and with regard to the remaining sum, account pay checks were issued. Now, this account pay check was presented and was dishonored on the ground that payment was stopped by the drawer. Now, in the meantime, the respondents, they filed a criminal petition before the then Guwahati High Court, assailing the Umiam PS case, and also a complaint case which was filed by the petitioner on the check being dishonored. Now, the then Shillong bench of the Guwahati High Court, vide its order passed in criminal petition number 40 of 2010, quashed both the proceedings. Against that, the petitioner went to the Supreme Court by filing a special leave petition. The Supreme Court, thereafter, after hearing the petitioner, restored both the cases. And this case was proceeding in the CR case was proceeding before the magisterial court. Now, what had happened was, the case was put up before the court and summons were issued to the respondent. The respondents did not receive the summons. Thereafter, summons were served on repeated occasion. Then thereafter, BWA was issued on the respondents. The respondents, the BWA could not be executed, though it is the same address. When on based on which the respondents had filed the criminal petition and also appeared before the Honorable Apex Court in the SLP. For some reason, the BWA could not be executed. On two occasions, the BWA were issued. Now, the BWA was not executed. The summons were not received by the respondents. Then what happened? On a given date, the counsel for the petitioner failed to appear before the court. And the court, by the impugn order, which is at page 16 of the petition, dismissed
dismiss the CR case by taking recourse to section 256 CRPC. Now, my lord, the effect of an order passed under 256 CRPC is that it amounts to an acquittal. Now, 256 CRPC, if I may take my lord to 265 CRPC. Now, 265 CRPC, if I may submit, is incorporated in the procedural code so as to deter frivolous litigants from filing frivolous complaints. Now, what happens once a complaint is filed and the court takes cognizance of the complaint, issues process on the accused person, then the accused person has to appear before the court on every date fix. Now, there are many litigants, many unscrupulous litigants who have been filing these kind of frivolous complaints. So, to deter the process of filing of these frivolous complaints and to ensure that no annoyance is caused to an innocent accused person, 256 of the, I'll just take 256 of the CRPC provides for the concept of acquittal on dismissal of the complaint, even if for whatever reasons, even if for the reason of non-prosecution. Now, if I may just read 256. Yes. 256. If the summons has been issued to the complainant and on the date appointed for appearance of the accused or any date subsequent thereto, to which the hearing may be adjourned and the complainant does not appear, the magistrate shall, notwithstanding anything herein before contained, acquit the accused unless for reasons he thinks it proper to adjourn the hearing of the case to some other day. Now, here one of the reasons which the court has assigned for taking recourse to 256 is that the court has held that the history of the case briefly encapsulated above in the above paragraph would indicate that this case is not being pursued with diligence. Now, my lord, I have taken this case right up to the apex court. My bona fide here cannot be questioned. The lawyer I had duly engaged a lawyer to appear on my behalf, failed to appear on the given date. Also, my lord, the notice could not be served on the respondent. The respondent were clearly, my lord, when an NBWA is issued, my lord, how is a NBWA enforced? NBWA is enforced through the police station. So, my lord, the respondent have taken all measures to ensure, to avoid the service of summons. And accordingly, the court, holding that I was not diligent enough, took recourse to this particular provision and dismissed my complaint, which ultimately amounts to acquittal of the accused person from all liabilities of the case.
You had said that only on one occasion you were absent.
Yes, ma'am.
But the order says otherwise.
My lord,
paragraph 3 says you were not found
on two dates, my lord.
On 15/12.
On 29/3/2022 and on 15/6/2022.
No. On 15/12.
Yes, ma'am.
11/3/22/4.
No, my lord. Thereafter.
No, 22/4 you appeared.
My lord, I appeared. And on 5/1/2022, I filed a report indicating that the BAWA was not executed due to insufficient address.
Right. So on 29/3.
Thereafter, on 29/3 and on 15/6, I was not represented. Now, my lord, my contention is that 256 would not have been taken recourse to, considering the fact that the service of summons was not complete. Because 256 clearly provide that after the summon has been served, and if date is fixed for appearance of the accused person,
okay,
appointed for the appearance of the accused or any day subsequent thereto, to which the hearing may be adjourned. So this was not the case. The complaint was at a very infant stage, at a very early stage. So therefore, it could not have, the court could not have taken recourse to this. Now, my lord, otherwise also, my lord, the law is fairly settled that for the fault of the counsel, a diligent litigant should not ordinarily be made to suffer.
Would that be applicable in criminal jurisprudence? Would that be applicable, that concept of?
My lord, in my submission, my lord, it should apply. It will apply, my lord.
Do you have any authority on that?
My lord, this again relates to service matter, but here, my lord, reference is given to some cases in criminal appeals. Now, in one such appeal, my lord, this is Department of Horticulture, Chandigarh State, and another versus Raghu Raj.
What is this edition?
2008, volume 13, SCC 395.
You have not given the.
My lord, I have not. I'm so sorry, my lord. I have not supplied the list of books.
Are you referring to how many authorities are you referring to?
My lord, I have a judgment of the Madras High Court, my lord. A similar case when the Madras High Court has said that 256 cannot be recourse to.
Where is that?
I have a copy of it here. Here also, my lord, even before the case was taken to file, my lord, finding that the complainant had not appeared, the court dismissed the complaint. And the court held that 256 cannot be taken recourse to at that stage, at that early stage. And in 2018, volume 13, SCC, Department of Horticulture, State of Chandigarh versus Raghu Raj, at paragraph 27, a reference to a case reported in 1994, volume 4, SCC 564 is made. That is the case of Mangilal versus State of MP. It reads as under: in Mangilal versus State of MP, an appeal against conviction recorded by the trial court was dismissed by the High Court for non-appearance of the counsel for the appellant due to strike by the lawyers. The court held that dismissal of appeal by the High Court was improper. The appeal was directed to be restored on file and to be heard on merits. So, my lord, this plea will apply, my lord, because once, my lord, the principle involved here is once a litigant engages a lawyer, pays his fees, executes a wakalatnama, then he has a bona fide belief that the lawyer will appear on his behalf before the court on every date in which his presence is not necessary, and his presence can be dispensed with, and the lawyer can appear on every date he will appear. Now, failure on the part of the lawyer to do so, my lord, should not ordinarily come in the way of a diligent litigant who has been diligently pursuing his cause. And my lord, here the facts of the case would clearly indicate, my lord, that I have gone right up to the Supreme Court, my lord, right up to the Supreme Court to enforce my right. Now, why at this stage, my lord, I will be held as not being diligent, or I will be held otherwise, my lord? If at all I was not very serious about my case, I would have not travelled all the way to the Supreme Court.
Yes. This Madras High Court, you have not referred to any paragraph?
My lord, Madras High Court, my lord, I'll just refer to it, my lord.
It is not reported.
No, it is not a reported case, my lord. I have got this judgment from the site of the website of the Madras High Court only, my lord. Paragraph 8 and 9, my lord.
Yes.
Section 256 is the only provision which deals with the dismissal of the complaint leading to the acquittal of the accused. As per the provision, it will be applicable only if the complaint is taken on file and summons is issued to the accused, and on the date fixed for appearance of the accused, accused on or his or her appearance. If the complainant does not make an appearance, the magistrate shall acquit the accused unless for some reason it thinks it proper to adjourn the hearing of the case to some other date. The object of the provision is that the court should take serious note of the absence of the person who has approached the court and set the law in motion, where the accused person makes himself present before the court for the inquiry. So, my lord, the entire object of incorporating the rule of acquittal on the ground of non-appearance of the complainant in section 256 is to deter unscrupulous litigant from filing frivolous complaint and causing undue hardship to innocent accused persons, my lord, to innocent respondents. This is, I have done research on this entire thing. This is the only judgment I could find. Otherwise, also there are judgments from Bombay High Court and other High Court. They also say the same thing, that if a complaint is filed, summon is issued to the accused person appears on the given date before the court. However, the complainant does not appear. Then, for reasons to be recorded in writing, the court will take recourse to section 256 CRPC, dismiss the complaint, which in fact will have which will have the effect of acquittal of the accused person. So, my lord, that's my only submission, my lord. In the in the facts and circumstances of the case, the court ought not to have taken recourse to section 256 and acquitted the accused person on the ground on non-appearance of his duly engaged counsel, because it was at a stage where the summons, where the process, where the service of process was not complete, my lord. Had the service of service of the process was complete, and had the accused person made an appearance before the court and the complainant failed to appear, then only in that case the court, that too for reasons to be recorded in writing, ought to have dismissed the complaint, leading to the acquittal of the accused person. So that is my submission. I will make a photocopy of this and I will supply to the court master of the case law.
Yes, you should have given the citation earlier.
Citation, my lord, I ought to have given, my lord. My apologies, my lord. Kindly be excused for that.
So you do that. I'll pass this to your order.
Okay. Oblige.
From daily cost list, item number 14.
Your Lordship, my senior Mr. R. Devnar is engaged in another court.
Who's for the petitioner? None has appeared on behalf of the petitioner. Respondent is present. Accordingly, this is matter up to 2 weeks.
Hello, Vice.
You're here in this case?
Lordship, I just in the other court. Lordship, I'll have to take instructions from my client, because what happened in this case, he had already got promoted. He had already got promotions in last year, in the month of May, Lordship. Promotion to the post of Subedar. So now whether he wants to pursue this matter, that only that limited instructions.
Okay, this is the case where he was. What is the case about?
Lordship, this is a case whereby the petitioner was due for promotion from the post of Naib Subedar to Subedar. Now he was denied promotion because he lacked ACR.
Yeah.
Now that ACR was not communicated to me. I've approached this honorable court. This honorable court has disposed of by directing the respondents to communicate the uncommunicated ACR, and if a representation is preferred by me, then they have to pass a speaking order, whether the ACR will be regularized or not. Now they have communicated the ACR and they have also passed a speaking order. Now in the speaking order, they only give a reason saying that we will not grant you promotion because that will create a floodgate. That is the only finding given by them. Now against that, we had approached this court challenging that speaking order. Now in the meanwhile, last year he had got promotion. So whether that promotion, maybe we will have to take instructions.
Unless and until he demands promotion
Retrospectively or prospectively, that is the only issue, Lordship. Allow me 2 weeks time, Lordship, to take instructions, then we'll come back, Lordship.
Fine. Mr. ML Nupio, learned counsel for the petitioner, has submitted that he may be allowed to seek instructions in this regard, in as much as it is reliably learned that the petitioner has since been promoted to the post of the rank of Subedar. As prayed for, this is not after 2 weeks.
Obligation, Lordship.
Second call, item number 2.
Lordship, the LC records are before this honorable court, Lordship, and I flagged the relevant pages, Lordship.
What is the stage of the case?
My charge sheet has been filed. Charge sheet has been filed.
Oh.
Now, my lord, if the procedure has been followed, then my lord, of course, I will not argue
The first
further on
flag,
that.
my lord. The first orange flag, Lordship. That is the order passed by the special court, Lordship, with regard to the arrest of the applicant herein. Or the... Which date? It shows 11.
Yes, I think she has been produced.
If she has been, well, because I was submitting on the basis
second
of...
orange flag, Lordship, that is the medical report, Lordship, the medical examination, Lordship. Lordship, if you kindly go just to the last portion, Lordship, she was advised to be taken for ART at Jowai Civil Hospital, Lordship. That is the treatment for HIV positive patients,
That's what they
Lordship.
do.
Lordship.
No, as far as maybe she may have been produced, may have been referred to Jowai Civil Hospital,
Lordship.
but the treatment given, if at all, if what the petitioner has submitted, that she is made to buy her own medicine,
Lordship.
for which her son has to come and all those things, then that cannot be, because these are government.
Actually, the government...
They have to. And this court has noticed, not only in this case, yes, some other government hospitals,
Lordship.
for which they compel the patients to go and buy medicine.
It came out in the news just some days back also, Lordship. Yes, yes.
Some of which are even costly.
Very costly.
I think there's one case pending for this court on that.
Lordship. But in this case, Lordship, if maybe from the government side also we can write to the jail officials, Lordship. Because that the medical report is there that she has to be taken, Lordship, to Jowai Civil Hospital for ART, Lordship.
This was, this is as far back as April.
April, Lordship, 11th of April, Lordship. So, but with regard to the presently, Lordship, I don't have any instructions. I will seek instructions, and accordingly, Lordship, we will send a letter to the government that ART has to be provided for such patients, Lordship. We can't just let them be at the mercy of anybody else.
Firstly, proper medical, treatment has to be given.
Lordship.
And I may be wrong, but in my opinion, medicine should be free.
Lordship. Lordship, with regard to that, Lordship, I'll have to seek instructions, but nevertheless, Lordship, as it has been stated over there, because they were already having knowledge that she was already in custody, Lordship, so they had sent her to the government hospital. We'll accordingly communicate on the same, my lord.
My lord, even medical report may be called for, my lord, because my lord, I am now pressing bail on the fact that she's an HIV patient.
We'll call for medical report.
Yes, my lord,
This
if-
court has not called for medical report.
No, my lord, medical report was not called.
I think the case record was not required to be called. I said the case record is not required to be called for because the matter is ongoing.
Lordship, that was an order passed by this honorable court,
Yes,
Lordship.
that's what I
Lordship generally calls for copies.
Copies, extract copy, Lordship.
but you have brought the original.
My lord.
Henceforth, you see, if court calls for record, only the relevant portion.
Extract copy,
extract copy could be.
Lordship.
Otherwise, unnecessarily,
It delays the
delays
trial.
the proceeding, and it acts as a de facto stay on the proceedings,
My lord.
which is not
Lordship.
preferable. Heard Mr. T.C.H. Gautam, counsel for the petitioner. Also heard Ms. N. Shishila Lalit, senior GE, appearing for the state respondent. In this instant application, which is an application for grant of bail, on behalf of the accused person in accused person under bracket X name withheld. What is the provision of the HIV Act?
34, my lord. Section 34 of the Human Immunodeficiency Virus and Acquired Immune Deficiency Syndrome Prevention and Control Act 2017.
Penuntut Umum. Miss what Miss so X name withheld, I under bracket name withheld in view of the provision of section 31 under bracket I under bracket A small a of the Human Immunodeficiency Virus and Acquired Immune Deficiency Syndromes Prevention and Control to under bracket Act of 2017. Apa lebih yang tu kayu ngomong? The Learned Counsel has stressed on the fact that the accused being an HIV positive patient has not been provided adequate medical treatment by the authorities concerned and was made to provide for her own medicines, for which she has to procure the same from outside sources. On this ground, this prayer for grant of bail has been made. On this ground, among others, petition for prayer for grant of bail is made. The Bernard CAG, on the other hand, has submitted that the court would show that the said accused has been referred to the Jawai Civil Hospital to start the ART. What does ART means?
AR treatment, Lordship. That's all I can remember.
I recall, but I haven't.
Yes. Yeah, only for HIV.
So I know capital no ART treatment. However, it is not known as to whether the same has been.
My lord, it is antiretroviral therapy.
From talk to her and antiretroviral
Viral therapy.
therapy. I think this is only with regard to HIV.
My lord. Only HIV.
The application, Lordship?
No, the term.
Or your Lordship?
Since counsel appearing for the respective parties have not been able to give a clear picture of the latest medical status of the said accused. Therefore, the prosecution is directed to file the said latest medical status of the said accused on the next date fix. This is matter on 25th.
Lordship.
Monday.
Much obliged, Lordship.
In the meantime, the low court record, trial court records, which has been produced before this court, is hereby directed to be returned, and if required in future, necessary orders will be passed.
Much obliged, Lordship.
Second call, item number 3.
My lord had called for the CD of this case. My lord, CD has come along with this statement number 164.
Yes, anything, Mr.
My lord, from this CD, my lord, it appears at the last page, my lord.
Last page.
Last page, page number 14.
Yes.
Here it shows that accused has appeared before the IO, and his statement under 161 was recorded. And 164 statement also, my lord, of the victim is before your lordship for your perusal.
So if you have appeared before the IO, your
Where is the
statement.
question of my lord custodial my lord?
Where is the question of apprehension now?
My lord, from 15th onwards, my lord, I have been cooperating with the investigations, my lord. My lord, the manner in which, my lord, the allegations of 164 has been given with such, my lord has seen on the last occasion also, my lord, how desperate is a complainant to get me arrested, to the point that she has even lied in 164. That will come out later on, my lord.
saying that at gunpoint she was asked to take a medicine, my lord. That's perjury, my lord. In my humble submission, my lord. I don't have a gunman, I don't have a PSO, my lord. And she is alleging against an innocent person of putting a gun on her head and forcing her to take medicine, my lord. And in the FIR, my lord, if that be the case, then even this FIR could have been, appears that it has been written at a gunpoint. Will I send somebody to at a gunpoint to write an FIR against me?
That is a matter of evidence.
My lord, these
Evidence,
are
my lord.
evidence,
Now,
my lord.
my lord will not be able to come into
Exactly,
any
my lord. This
conclusion.
is what I'm trying to impress upon my lord. Is that, my lord, now, my lord, there is no ground for sustained or custodial interrogations. I'm fully cooperating, my lord. Let the truth unveil, my lord. Rest, my lord, I leave to my lord a few judgments that I have cited, my lord. That is all, my lord.
What is the charge has not been filed?
My lord, search sheet is not yet filed, my lord. Still under investigation.
Is there any report by the IO that the petitioner is required for custodial
My lord,
interview?
my lord will see case number 14, my lord. The below portion.
Yes. So he has been directed to appear for the IO and to cooperate, and he must have done so.
I have, my lord, I'll just give which days I have appeared, my lord.
15/9.
I'm fully cooperating with the investigations, my lord. I'm not shying away, running away. And here they could not arrest because my lord's interim protections were there, my lord. Here, my lord. And I'm willing to cooperate, my lord, in the days to come also, my lord, fully, my lord. Let the truth unveil, my lord. That is all, my lord.
Lord, if my be allowed to make a little submission on behalf of the complainant. My lord, what my learned friend has suggested, that he's been appearing, that is only on the strength of the interim order, either by this court or the trial court. They have moved this bail application before the trial court also, and they were granted interim. On the strength of interim, they have appeared before the concerned IO, my lord. Here the question, if your lordship will peruse the statement under 164 recorded by the magistrate concerned, your lordship will see that it is not only section 315, but 493 is also attracted, my lord, if not 375. Because there is an element of 375 as well, my lord. The statement will clearly indicate, my lord, that there was a promise made by the petitioner to the respondent. Only then she entered into such kind of a relationship. That promise was there, my lord. So I'm just highlighting, your lordship. It's a matter of investigation, my lord.
You go through a number of Supreme Court judgment on this.
My lord, that is there, man. Even if it is not there, 375 ingredients, but at least 493 is definitely there, my lord.
See, Mr. Mansoori, whatever the case may be, the case is at the investigation stage.
My lord.
It is the prerogative of the IO.
My lord.
As to how to conduct the investigation.
Correct. I'm not questioning on that, my lord.
And if the accused,
my lord,
is cooperating,
my lord,
appearing,
my lord,
his statement is duly recorded, or whatever is required of him is received.
My lord. But my lord,
there
are certain facts which has to be ascertained, and that 161, my lord, he has not been cooperating. 161, the statement, the allegation against him, and the statement of the complainant, my lord. If your lordship will see,
there is no noting of the IO to that extent. No noting that he's. See, this is the last, last recorded, portion of the CD. That is on 15/9.
my lord.
Nothing is said here that he is not cooperating.
It's not about the
Nothing
question.
is said here that is what
My
whatever
lord,
is
the
required of him is
statement
not.
of the statement of the petitioner, my lord.
That
There are so many allegations, my lord, that has to be clarified, and that can happen only into the custodial interrogation, not otherwise, my lord, because he's a influential person, my lord.
that's too far-fetched.
Influential person, and he has been that gunman story, my lord, which my learned friend has said, it's absolutely correct. He's a politician, my lord, and he has got reach.
Exactly.
He has a reach.
Exactly.
In fact,
those are all.
he has tried to manipulate even the police.
Those are all matters of.
this is
Those are all
absolutely
matters
wrong.
of trial.
No.
How can that be? How will I manipulate?
That is
This has gone too much.
No.
Look
No,
at
no.
the conduct of this lady.
No.
Personally attack me also.
No. That
What are we
is
going to
out
do
of
this
anger.
for?
That is out of anger. That I can explain, my lord. How
So
this is
this
out of
FIR
anger.
is also out of anger.
No. That is not absolutely. Your lordship will see
Lying
the statement, my lord, under 164, which will reveal the entire fact of the case, my lord.
Exactly.
164, my lord. She has in detail. She has given the instances and circumstances which has taken place, and how it has taken place, my lord. Now that gunpoint, giving her the pills for terminating the pregnancy, my lord, 315 is definitely attracted, my lord. There is no question about it. And as far as the promise is concerned, your lordship, 493 in a day or two, my lord, I presume, I guess, my lord, that the investigating officer will definitely add this section as well, because the case fits very well, my lord.
That's
Now
that is for the IO to.
correct. I presume, my lord, because the element of that thing is there. The offence under 493, that element is very much present, my lord, in that case, if your lordship will produce. And how she has been made to suffer, my lord. She has been hospitalized for 10, 12 days, my lord. It was on her life. She was about to die, my lord, if proper medication was not given to her in time. She was admitted in Ganesh Das hospital for 12 days, my lord. Only then thereafter she recovered,
Exactly, Mr. Masuri. If all those facts are proved,
my lord.
see, finally,
I understand, my lord, but
finally-
this is a bill
finally
state.
he will be convicted.
Correct, true, my lord. But then, for the purpose of investigation, my lord,
I don't see any reason why a person should be in custody and he has to be interrogated in custody. You see, nowadays court doesn't look kindly to custodial interrogation.
My lord.
Lordship, I humbly pray that before considering this bail application, your lordship may kindly go through the statement of the victim, my lord.
Obliged, lordship.
I'll humor you and I'll go through it.
My lord. Obliged, lordship.
Obliged.
Pass his orders. You sure?